The Single Convention on Narcotic Drugs of 1961 is an international treaty to prohibit production and supply of specific drugs and of drugs with similar effects except under license for specific purposes, such as medical treatment and research. As noted below, its major effects included updating the Paris Convention of 13 July 1931 to include the vast number of synthetic opioids invented in the intervening 30 years and a mechanism for more easily including new ones. From 1931 to 1961, most of the families of synthetic opioids had been developed, including drugs in whatever way related to methadone, pethidine, morphines and dextromoramide and related drugs. Research on phenytiles and pyritramide was also nearing fruition at that point. Earlier treaties had only controlled opium, coca, and derivatives such as morphine, heroin and cocaine. The Single Convention, adopted in 1961, consolidated those treaties and broadened the scope to include cannabis and drugs whose effects are similar to those of the drugs specified. The Commission on Narcotic Drugs and the World Health Organization were empowered to add, remove, and transfer drugs among the treaty's 4 schedules of controlled substances. The International Narcotics Control Board was put in charge of administering controls on drug production, international trade, and dispensation. The United Nations Office on Drugs and Crime was delegated the board's day-to-day work of monitoring the situation in each country and working with national authorities to ensure compliance with the Single Convention. This treaty has since been supplemented by the Convention on Psychotropic Substances, which controls LSD, MDMA, and other psychoactive pharmaceuticals, and the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, which strengthens provisions against money laundering and other drug-related offenses. As of February 2015, the Single Convention has 185 state parties. The Holy See plus all member states of the United Nations are state parties, with the exception of Chad, East Timor, Equatorial Guinea, Kiribati, Nauru, Samoa, South Sudan, Tuvalu, and Vanuatu. Influence on domestic legislation. Since the Single Convention is not self-executing, parties must pass laws to carry out its provisions, and the UNODC works with countries' legislatures to ensure compliance. As a result, most of the national drug statutes in the UNODC's legal library share a high degree of conformity with the Single Convention and its supplementary treaties. The 1971 Convention on Psychotropic Substances and the 1988 United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances. The Single Convention has been used as the basis for the standardization of national drug control laws. In particular, the United States' Controlled Substances Act of 1970 and the United Kingdom's Misuse of Drugs Act 1971 were designed to fulfill treaty obligations. Both acts include analogous schemes of drug scheduling, along with similar procedures for adding, removing, and transferring drugs among the schedules. The Controlled Substances Act follows the Single Convention's lead in granting a public health authority a central role in drug scheduling decisions. It also includes a provision mandating that federal authorities control all drugs of abuse in accordance with the strictness required by the Single Convention. History. The League of Nations adopted several drug control treaties prior to World War II, specifying uniform controls on addictive drugs such as cocaine and opium, and its derivatives. However, the lists of substances to be controlled were fixed in the treaty's text. Consequently, it is necessary to periodically amend or supersede the conventions through the introduction of new treaties to keep up with advances in chemistry, In a 1954 interview with Harry J. Anslinger, who was the United States Commissioner of Narcotics at the time, the cumbersome process of conference and state-by-state ratification could last for a period of numerous decades. A Canadian Senate committee report notes, the work of consolidating the existing international drug control treaties into one instrument began in 1948, but it was 1961 before an acceptable third draft was ready. Quote, that year, the UN Economic and Social Council convened a plenipotentiary conference of 73 nations for the adoption of a single convention on narcotic drugs. That meeting was known as the United Nations Conference on Narcotic Drugs. Canadian William B. McAllister, Q.C., notes that the participating states organized themselves into 5 distinct caucuses. Organic States Group, as producers of the organic raw materials for most of the global drug supply. These countries had been the traditional focus of international drug control efforts. They were open to socio-cultural drug use, having lived with it for centuries, while India, Turkey, Pakistan and Burma took the lead. The group also included the coca-producing states of Indonesia and the Andean region of South America, the opium and cannabis-producing countries of South and Southeast Asia, and the cannabis-producing states in the Horn of Africa. They favored weak controls because existing restrictions on production and export had directly affected large segments of the domestic population and industry. They supported national control efforts based on local conditions and were wary of strong international control bodies under the UN. Although essentially powerless to fight the prohibition philosophy directly, they effectively forced a compromise by working together to dilute the treaty language with exceptions, loopholes and deferrals. They also sought development aid to compensate for losses caused by strict controls. Manufacturing States Group. This group included primarily Western industrialized nations, the key players being the United States, the United Kingdom, Canada, Switzerland, the Netherlands, West Germany, and Japan. Having no cultural affinity for organic drug use and being faced with the effects that drug abuse was having on the citizens, they advocated very stringent controls on the production of organic raw materials and on illicit trafficking. As the principal manufacturers of synthetic psychotropics, and backed by a determined industry lobby, they forcefully opposed undue restrictions on medical research of the production and distribution of manufactured drugs. They favored strong supranational control bodies as long as they continued to exercise de facto control over such bodies. According to W. B. McAllister's drug diplomacy in the 20th century, the strategy was essentially to shift as much of the regulatory burden as possible to the raw material producing states while retaining as much of their own freedom as possible. Strict control group. These were essentially non-producing and non-manufacturing states with no direct economic stake in the drug trade. The key members were France, Sweden, Brazil, and the Republic of China. Most of the states in this group were culturally opposed to drug use and suffered from abuse problems. They favored restricting drug use to medical and scientific purposes and were willing to sacrifice a degree of national sovereignty to ensure the effectiveness of supranational control bodies. They were forced to moderate the demands in order to secure the widest possible agreement. Weak control group. This group was led by the Soviet Union and often included its allies in Europe, Asia and Africa. They considered drug control a purely internal issue and adamantly opposed any intrusion on national sovereignty, such as independent inspections. With little interest in the drug trade and minimal domestic abuse problems, they refused to give any supranational body excessive power, especially over internal decision-making. Neutral group. This was a diverse group including most of the African countries, Central America, Sub-Andean South America, Luxembourg and the Vatican. They had no strong interest in the issue apart from ensuring their own access to sufficient drug supplies. Some voted with political blocs, others were willing to trade votes, and others were truly neutral and could go either way on the control issue depending on the persuasive power of the arguments presented. In general, they supported compromise with a view to obtaining the broadest possible agreement. These competing interests, after more than 8 weeks of negotiations, finally produced a compromise treaty. Several controls were watered down. For instance, the proposed mandatory embargoes on nations failing to comply with the treaty became recommendatory. The 1953 New York Opium Protocol, which had not yet entered into force, limited opium production to 7 countries. The single convention lifted that restriction, but instituted other regulations and put the International Narcotics Control Board in charge of monitoring their enforcement. A compromise was also struck that allowed heroin and some other drugs classified as particularly dangerous to escape absolute prohibition. The single convention created 4 schedules of controlled substances and a process for adding new substances to the schedules without amending the treaty. The schedules were designed to have significantly stricter regulations than the 2 drug groups established by predecessor treaties. For the first time, cannabis was added to the list of internationally controlled drugs. In fact, regulations on the cannabis plant, as well as the opium poppy, the cocobush, poppy straw and cannabis tops, were embedded in the text of the treaty, making it impossible to deregulate them through the normal scheduling process. A 1962 issue of the Commission on Narcotic Drugs, Bulletin on Narcotics, proudly announced that, after a definite transitional period, all non-medical use of narcotic drugs, such as opium smoking, opium eating, consumption of cannabis and chewing of coca leaves, will be outlawed everywhere. This is a goal which workers in international narcotics control all over the world have striven to achieve for half a century, and the 3rd of August 1962 Economic and Social Council resolution ordered the issuance of the commentary on the Single Convention on Narcotic Drugs. The legal commentary was created by the United Nations Secretary-General's staff, operating under a mandate to give an interpretation of the provisions of the convention in the light of the relevant conference proceedings and other material. The commentary contains the Single Convention's legislative history and is an invaluable aid to interpreting the treaty. The Single Convention entered into force on the 13th of December 1964, having met Article 41's requirement of 40 ratifications. As of the 1st of January 2005, 180 states were parties to the treaty. Others, such as Cambodia, have committed to becoming parties. On the 21st of May 1971, the UN Economic and Social Council called a conference of plenipotentiaries to consider amendments to the Single Convention. The conference met at the United Nations office at Geneva from 6 to the 24th of March 1972, producing the 1972 Protocol amending the Single Convention on Narcotic Drugs. The amendments entered into force on the 8th of August 1975. On the 11th of November 1990, mechanisms for enforcing the Single Convention were expanded significantly by the entry into force of the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, which had been signed at Vienna on the 20th of December 1988. The preamble to this treaty acknowledges the inadequacy of the single convention's controls to stop steadily increasing inroads into various social groups made by illicit traffic in narcotic drugs and psychotropic substances. The new treaty focuses on stopping organized crime by providing for international cooperation in apprehending and convicting gangsters and starving them of funds through forfeiture, asset freezing, and other methods. It also establishes a system for placing precursors to scheduled drugs under international control. Some non-parties to the single convention, such as Andorra, belong to this treaty and thus are still under the international drug control regime. Medical and other drug uses. The single convention repeatedly affirms the importance of medical use of controlled substances. The preamble notes that the medical use of narcotic drugs continues to be indispensable for the relief of pain and suffering, and that adequate provision must be made to ensure the availability of narcotic drugs for such purposes. Articles 1, 2, 4, 9, 12, 19, and 49 contain provisions relating to medical and scientific use of controlled substances. In almost all cases, parties are permitted to allow dispensation and use of controlled substances under a prescription, subject to record-keeping requirements and other restrictions. The single convention unambiguously condemns drug addiction, however, stating that addiction to narcotic drugs constitutes a serious evil for the individual and is fraught with social and economic danger to mankind. It takes a prohibitionist approach to the problem of drug addiction, attempting to stop all non-medical, non-scientific use of narcotic drugs. Article 4 requires nations to limit use and possession of drugs to medicinal and scientific purposes. Article 49 allows countries to phase out coca leaf chewing, opium smoking, and other traditional drug uses gradually, but provides that the use of cannabis for other than medical and scientific purposes must be discontinued as soon as possible. The discontinuation of these prohibited uses is intended to be achieved by cutting off supply, rather than calling on nations to prosecute drug uses. The treaty focuses on traffickers and producers. As of 2013, 234 substances are controlled under the single convention. Penal provisions. Article 36 requires parties to adopt measures against cultivation, production, manufacture, extraction, preparation, possession, offering for sale, distribution, purchase, sale, delivery on any terms whatsoever, brokerage, dispatch in transit, transport, importation and exportation of drugs contrary to the provisions of this convention, as well as intentional participation in, conspiracy to commit and attempts to commit any of such offenses, and preparatory acts and financial operations in connection with the offenses referred to in this article. Article 36 does not directly require criminalization of all the above. It states only in the cases of serious offenses that they shall be liable to adequate punishment, particularly by imprisonment or other penalties of deprivation of liberty. The article also provides for extradition of drug offenders. Although a party has a right to refuse to extradite a suspect if competent authorities consider that the offense is not sufficiently serious, a 1971 amendment to the article grants nations the discretion to substitute treatment, education, aftercare, rehabilitation and social reintegration for criminal penalties if the offender is a drug abuser. A loophole in the single convention is that it requires parties to place anti-drug laws on the books, but does not clearly mandate their enforcement, except in the case of drug cultivation. Drug enforcement varies widely between nations. Many European countries, including the United Kingdom, Germany, and, most famously, the Netherlands, do not prosecute all petty drug offences. Dutch coffee shops are allowed to sell small amounts of cannabis to consumers. However, the Ministry of Health, Welfare and Sports report, Drugs Policy in the Netherlands, notes that large-scale reduction and trafficking are dealt with severely under the criminal law, in accordance with the UN Single Convention. Each year the Public Prosecutions Department deals with an average of 10,000 cases involving infringements of the Opium Act. Quote, "Some of the most severe penalties for drug trafficking are handed down in certain Asian countries, such as Malaysia, which mandate capital punishment for offences involving amounts over a certain threshold. Singapore mandates the death penalty for trafficking in 15 grams of heroin, 30 grams of cocaine or 500 grams of cannabis. Most nations, such as France and the United States, find a middle ground, imposing a spectrum of sanctions ranging from probation to life imprisonment for drug offenses. The Single Convention's penal provisions frequently begin with clauses such as, subject to its constitutional limitations, each party shall... Thus, if a nation's constitution prohibited instituting the criminal penalties called for by the Single Convention, those provisions would not be binding on that country. However, Professor Cindy Fazy's A Growing Market, the Domestic Cultivation of Cannabis points out, whilst this strategy may be practical politics for some countries, critics will ask why it has taken almost half a century to discover that the UN Conventions conflict with a constitutional principle. The argument is particularly difficult to deploy for countries like Britain, where constitutional principles are not formalized or codified to any significant degree. However, the current move in Switzerland to enshrine cannabis decriminalization in the national constitution by popular initiative could profit. For this rule,